Business Law 1 class. Today we look at section 6 of unit 3 on vitiation factors, particularly public policy, illegality, and unconscionability. Session objectives. By the end of this session, you should be able to explain the term public policy, discuss the types of transactions that are illegal, and lastly, describe unconscionable contracts. Now let's deal with illegality. A transaction is illegal when the agreement itself or the performance of the act infringes on statute or precedent. So we are saying that before you can consider that a contract is illegal, then that contract should be in breach of a particular enactment or case precedent or case law, let me put it this way. Now, some of the illegal contracts are as follows. An illegal contract may be one, the term of which infringes on provisions of statutes or precedents. We are talking about a situation whereby a contract that you have entered goes contrary to a particular law that has been passed. And in such a situation, that contract becomes unenforceable because the contract is tainted with illegality. The contract cannot be enforced. It has been stated in Olitiboy v. Captain that the court will not assess a plaintiff to recover on an illegal contract. So this case seeks to establish that the court will not aid its assistance or support to a plaintiff where the contract is tainted with illegality. Now you should also understand that a contract may be perfectly legal. So this time when the contract is perfectly legal, but the purpose which the subject matter would be used for is illegal. So the contract itself is legal, but the purpose of the contract or the subject matter is illegal. Now, such contract cannot be enforced by the court. You should be aware that if the contracting party is aware that the subject matter is intended to be used for an illegal purpose, then the contract will be unenforceable. It means that you cannot enforce such contract. So where you enter into a perfect or legally binding contract, but the purpose or the rationale behind the contract is to achieve illegal purpose, such contract cannot be enforced at a law court. So look at the case of this particular case, the Hughes case. Also, a contract that seeks to indemnify a party against deliberate commission of crime would not be enforced. So when you enter into a contract to kill someone and the person fails to pay you afterwards, after you have done the killing, you will not be entitled to anything. You cannot enforce at the law court. Now, public policy. Public policy is difficult to define. However, any act that goes contrary to the conscience of the general public, it will be deemed to be constitute or it will be against public policy. Some of the examples include the following. An agreement involving or tending to the corruption of private citizens with reference to public matter. So when it is involved in issues of corruption, it's against public policy. A matter that any agreement tending to pervert or obstruct public justice. So if the agreement intends to obstruct public justice, that the agreement does not intend to bring justice to the society, such agreement will be against public policy. Any agreement to encourage litigation. You have the saying that litigation should come to an end. So any agreement that will encourage this litigation will also be against public policy and cannot be enforced at the law court. Agreement of immoral tendency. So any agreement that will lead to immoral or immoral conduct, such activity cannot be enforced at the law court because it is against public policy. Gambling transactions. Gambling transactions are also not permitted unless those ones that are regulated and permitted by law. We also have agreement tending to induce fraud or breach of trust. Those contrary to is against public policy and cannot be enforced at the law court. Now let's look at unconscionability. Unconscionability simply means that unjust or unfair transaction against one party. So you're saying that it is a term used to describe terms in a contract that are so assuming unjust, overwhelming one side in favor of a party who has the superior bargaining power, that they are contrary to good conscience. So what is you are saying that, look, the terms in the contract is more favorable to the one with the superior power, one with the high power, against the other party. In such cases, we declare that that contract is unconscionable because it is against the common conscience of the people in the society. Now, when a contract is said to be unconscionable, it cannot be enforced by the court. Let's consider some of the examples. Where a party that typically engages in sophisticated business transactions insert language into a contract containing terms unlikely to be understood. So when you enter into a contract, you put certain provision that it will not be understood by, it is being understood by only you, then such contract will be declared to be unconscionable. So or appreciated by the average person, such as disclaimer or warranty or provision extending liability for a newly purchased item to goods previously purchased from the same seller. In all those cases, that contract should be declared unconscionable. Also, a seller vastly inflates the price. So when a seller inflates the price of goods, particularly when this inflation is conducted in a way that conceals from the buyer the total cost for which the buyer will ultimately be liable. So unnecessary inflation is also against public, is also deemed to be unconscionable, and such contract cannot be enforced at the law court. Now also, where a seller offers a standardized contract for the purchase of necessary goods or service, for instance, food, shelter, and means of production, to consumers on take it or leave it, the take it or leave it basis, without giving the consumer the realistic opportunity to negotiate the term that will benefit their interest. That contract is also unconscionable. Take it or leave it means that you don't have any option than to take that particular product. So you don't have the opportunity to negotiate with the person to come to a fair conclusion or price of the subject matter. So the court will consider that contract to be unconscionable and unenforceable by the court. Session summary. In this session, we state that public policy dictates that illegal contracts are unenforceable, and the court should be vigilant not to enforce any contract with an illegal purpose. We said that the effect of illegality is unclear, but it will depend on the intention of the parties, as only an innocent party may be able to enforce after consideration of whether the contract is illegal per se or only in the manner in which the contract is performed. That is to say, only in the manner of its performance. Thank you and have a nice day.